Michael, you gave an excellent keynote speech. You, along with Marzuki and Sonia, authored that landmark COI report book, which I refer to in my introductory remark as a game changer in dealing with the North Korean human rights violations in North Korea. As the key author, what are your thoughts today? I mean, it's been almost 10 years. You know, above all, must have a lot of mixed feelings about about how things have transpired in that 10 years.
Well, I agree with what Marzuki and Sonia said about the way international affairs have gone in directions that were not favourable to accountability by legal process. Now, there was an interesting little vignette during our preparation of the COI report. I hope this audience appreciates the way we're breaking news and I'm revealing these inside stories. But at a certain point, we came to the view that the particular type of incident that Judge Song referred to is not something you can deal with without an incident happening and other things following up. But there is a principle in international law called the command principle. And that principle says that where a person who, being in command, has the authority to stop or prevent or address a breach of international law, then they will be personally liable. And I state the principle too broadly, but that's the command principle. And so we decided that we should give notice to Kim Jong-un, who had not taken part in our inquiry, about the fact that under the command principle he might be made liable, and to get his response. This led to two senses of outrage. In the United Nations, they said, he's a head of state. We never write to the head of state. And I said, he's not a head of state. He's the head of the party. But even if you say that he's a man with command responsibilities equivalent to a head of state, it is our duty under fair process because he has not appeared before us, to give him the opportunity to have a say on whether we should bring the matter before a prosecutor of the International Court. And that ultimately the United Nations couldn't do anything because we were determined and we thought it was a duty of fair procedure to give him a chance. And we did that, but we got no response. We sent the notice through the embassy of DPRK in Geneva. And so he was formally notified and he remains under that notification. And it was given back in 2014. And that presumably would be still available if the opportunity arises. It isn't true to say that the veto has been deployed on all occasions where a matter has been raised by a prosecutor of the ICC. As Judge Song has pointed out, the prosecutor has raised issues in respect of Libya and Darfur, and therefore that depends upon the determination of the Security Council, which requires the positive votes of the P5 members, the permanent 5 members of the Council. But the permanent 5 members have in the past taken steps against North Korea, which meant that the Russian Federation and China voted for them. These are matters relating to breaches of sanctions that have been imposed by the Security Council. because both Russia and China have their own concerns about the nuclear program of North Korea. So I think we did what we could do. We put them on notice against some degree of opposition within the UN family, and that notice is current. It upset the North Korean leadership greatly, and it meant that they had to take very seriously the report when it was going through the United Nations, including in the Security Council. But as Marzuki and Sonia have pointed out, since our report, things have not necessarily gone in the direction of answerability to international affairs. The two recent wars in Europe and the other international conflicts, the reduction in commitment on the part of many countries to the international rule of law, and the COVID crisis have sort of taken a bit of the pressure away. But it must not be abandoned. It is on the record. The record is there. The record reveals involvement of the Supreme Leader and other high officials of DPRK in crimes against humanity. And crimes against humanity came into international law as a result of the crimes of the Nazis and of the Japanese in the Second World War. And those crimes are of a kind that would lead to a proper investigation by international court and accountability on the part of the leaders of North Korea under the command principle.
Well, Michael, I do want to come back to your point on the command principle and responsibility. You suggested that the opportunity for this principle to be applied remains possible. As to what sort of opportunity you're talking about, we can talk about that